I don't become any the less saying it ceases to be an actionable claim because that is how Andraj tried to kill us at that particular point of time. And their lordships in the Constitution bench said, it's only one right. Don't go about, for heaven's sake, splitting it into umpteen rights, catching him on a right to participate, and so on. This is the genesis. There is nothing called in relation to, and ultimately the whole, it's a transfer of actionable claim. Lordship sees that transfer means you're transferring something on which you had a title, which is an actionable claim. So transaction and actionable claim doesn't disappear and take a different view in what a transfer and actionable claim is. This is what, as far as a judgment, there is nothing called in relation to. I just point out Andraj, my lords. To that extent, it's interesting.
Just tell us the paragraphs.
Yes, my lords. Where is my copy, my lords? Yeah, I got that. Yes, my lords, the paragraph in Andraj. Lordship goes to paragraph 29, my lords.
Yes.
And I think a lot of brainstorming would have gone in.
Yes, yes.
Lords, a lot of brainstorming would have gone in because you are at a death knell and the lordships are holding that way. Lordship sees para 29. Counsel for the dealers sought to raise. Mr. Ganesh was there. He's saying illustrious scholar. Sorry. Lordship sees para 29. Mr. Saralji, Mr. Parashan,
Dr. Y.S. Chitale.
I think Mr. Ganesh's name is also there. Somewhere I saw, no? Sir? Sunrise, you were there.
Mr. A.V. Rangam.
Yes.
He passed away recently. Mr. A.V. Rangam. Subhashini's brother.
Oh, yes. They were in the central government panel.
She was there. She was there.
I've seen.
He also passed away last year or year before.
Chip sees para 29 minutes. Counsel for the dealers sought to raise a further contention that the issue of a lottery ticket, like the issue of shares by a joint stock company, creates for the first time in the buyer the right to participate in the draw. That is to say, the right to have his number included among the participating numbers, and therefore there is no transfer involved in the issue of a lottery ticket. In other words, just as a company before it indulges in capital issue does not hold any of its shares, but only after they're issued they come into exist, only in the hands of shareholders and they're subscribing to them and an allotment to them. So in the case of a lottery, the promoter sponsoring it does not have the right to participate nor the right to claim a prize in a draw, and that these rights come into existence for the first time in the participant when he purchases the ticket, and therefore no transfer of any of the said rights is involved in the issue of a lottery ticket. And in this behalf, reliance was placed on the following passage from Kanga and Palkewal. Mallards, the share and company, etc., they said, no, forget about it. Lordship sees page over on the right side. Contention so put forward is, in my view, without any substance. In the first place, the capital issue is by joint stock companies governed by provisions of Companies Act and memorandum of articles, etc. Whereas the issue of lottery tickets would be governed by a raffle scheme and the rules framed therefore by the promoter, who in this instant case happens to be the state government, containing provisions entirely different from those governing issue of share capital. And thus is the analogy of capital issue by joint stock companies wholly inappropriate. Secondly, the learned authors were dealing with the case of amalgamation of two companies in the context of capital gains tax, while the learned law lord, as the report of the case shows, was concerned with construing the meaning of the word purchase, occurring in section 45, and held that acquisition of shares by the subscription or allotment was not a purchase within the meaning of that section. In other words, both the cases are in different contexts altogether. Right, my lords? Moreover, as discussed earlier, the agreement that comes into existence as a result of the sale of a lottery ticket by a promoter to a buyer is in the nature of a grant conferring the two rights, the right to participate and the right to claim a prize if successful upon such buyer. If this be true, the true nature of the agreement, it implies that both the rights come into existence and are with the promoter no sooner a raffle scheme together with the rules governing it, rules to fix the number of series to be issued, number of tickets in each series, the number of terms in which the prizes are to be rewarded, etc. sponsored, published, and the tickets are offered for sale, and these rights are transferred upon the sale of ticket to the purchaser. The mere fact that under the rules, the promoter is disabled from participating in the draw or from claiming a prize in such a draw does not mean that these rights do not come into existence or are not with the promoter before the actual sale of the tickets to the buyer, nor does it mean that these rights come into existence time only upon the sale of ticket to the buyer as urged by the counsel for the dealers. Such disability imposed upon the promoter by the rules is necessary to create confidence in the participants about the promoter's bona fides in the raffle scheme, and thus prevents the scheme from being viewed as a fraudulent or a fishy affair. Right, fellows? Then, in other aspect that lottery tickets are more in the nature of choices in action because of the right to claim a prize by chance, has observed that these are merchandise though in a limited sense. The aforesaid aspect of the matter really clinches in my view the position that for the purpose of imposing levy of sales tax comprising the entitlement to right to participate in a draw, will have to be regarded as goods properly so called. So, my lords, to again explain what is going
So
on.
they said it's goods for the purpose of sales tax,
Right,
so that the sales tax could be imposed.
right. So, therefore, they swung in between. They did not take it as a
Now under GST, it is again goods.
my lord, GST. I'll come to that. In fact, I was anyway. My lord, let's come to this. So, therefore, they didn't swing the entire direction saying it's a transfer of an actionable.
You have not challenged the imposition of tax in GST under GST.
Challenged and lost.
Where?
Larger bench of this court, my lords, has declared that
Where?
in skill lotto, my lords,
Lotto, yes, yes.
they challenged the levy and my lords, it was upheld.
I'm very grateful to my learned friend. What we lost there is that when the state government is selling to us, is deemed to be a sale, and therefore under GST it's regarded as a sale, and therefore I'm supposed to pay. And we also lost in what should be the value, because my lords, there is.
No, that is what he is taking advantage of that to say that it is ultimately one of sale.
I'm taking advantage.
Yeah, yes.
I'm grateful. That is what I'm saying.
That's what you started with.
That's my lords, I've been
That's
trying
what
to.
that is what he started his argument with.
If you are treating it as a sale of lottery tickets, nothing has changed. Today, how do I become an agent, my lords? This is what I was saying right from the beginning. So what has happened in GST legislation?
No, but that in GST your avatar is different. That's what they will say subsequently. From 2017 you are different
My lords,
because they have amended. They have given a definition to the lottery
my lords,
business.
coming to that avatar, I'll only say white man speaks with folk tongue and they're the white man. What they're doing is, earlier they want me to be a agent. I cry horse and I say I'm not an agent. Then under GST they say it's an outright sale. If it were an agent, my lords, I would be caught saying that there is a particular consideration you're receiving from the state government, you have to pay. They're going after the state government by a reverse charge, of course, now. They're saying state government is selling to you. So the position they've accepted that it's an outright sale today. This is what they're doing in GST. I do not think that the state should participate this way and keep changing the stance, my lords. Nothing has changed. Contracts are still the same. And come after 2017, yes, state government is selling to you. There's something called reverse charge, my lords, in service tax and
Yes.
GST. Lordship is aware. Let's say, all right, we'll put that duty on you. And what value we will take? Not at sale price. We will take the entire face value. They can do it. There's a section 15 says, government can determine whatever can be the value, not even the transaction value. They've gone that far.
See, that's why they have found that all this was foul earlier. Everywhere you were succeeding. Even here you succeeded. So they changed the definition itself and made it goods. They have come back to Justice Tuljapurkar's definition.
And made it goods and said that it's the state government which is selling. So that sale model is what they've accepted. Today they're no longer on that you're an agent, etc., falana, whatever they're arguing now. I'll become, my lords, an outright purchaser, but so be it, on reverse charge. We'll go
Yes.
and take the money. So just, my lords, not even a decade, 2017, pre and post, I don't know whether Article 14 applies, this is what they're doing.
They are entitled to amend, define.
And keep on changing the stance. It's not like a chameleon, I think. Any case, so therefore, Anraj, what it did, my lords, when the SSCs found they were desperate, they took this wonderful.
Like after works contract, Gannon Tankerley won, they amended the constitution.
We have no problem. But then
Yes.
when they've amended, they're not deemed it to be a sale or deemed it to be an agency or anything. They're saying it's a sale. They've accepted that. If it be a sale prior to post 2017, so
So you're saying you're in the business of lottery, it is nothing to do with, a business of lottery means business of actionable claim.
transaction in actionable.
Yes,
Which
therefore
I-
it is nothing in relation to. What they went is, you are outside the actual, gambling.
Yes, yes.
You are not a gambler. You are in relation to actionable claim you are dealing.
My only.
But a person who actually buys the ticket to gamble, he is buying an actionable claim. That is their argument.
We'll come to entry 62 also, my lords,
Hmm.
where all promoters are broken. But suffice it to
Entry
say,
62 you are paying. No dispute.
yes, therefore, for that reason also, I should not be caught in their net under service.
That argument, Mr.
I'll add a
Ganesh.
little bit to that. Well, so therefore, Anraj was when very brilliantly the SSCs took the argument that I don't have any right, as my learned friend is saying, you don't have any right, etc. This has been overturned, saying this we accept what they're saying, but where Justice Tuljapurkar went wrong, which the Constitution bench says is both the rights, you can't go on splitting those rights. It's only one right, it's a transfer of actionable claim. Therefore, under sales tax, no tax is leviable.
What is
So-
that citation that
Yes.
Constitution bench?
Constitution bench, my lords, he has put it. Yes, he's put in volume 2, page 567. Give me that. Volume, my copies. Yes.